This month's issue of the Wisconsin Law Journal is on ADR, and they asked me if I would dedicate my column this month to family law mediation, which I've done. And I want to talk to on the video today about one section, one part of the article, and maybe expand upon it a little bit. Let me start with that. To me, the greatest change in family law since I've been practicing, as I've said before, is the concept of use of mediation in settling cases. I was hired by this firm as a litigator, and I used to try and litigate a lot of cases. And in today's world, we settle virtually everything. And I'm convinced mediation is one of the primary reasons for that. And the litigation rates have gone down to what's almost a minuscule level today, whereas the settlement rates have gone up significantly. And mediation used to be used, first it wasn't, well, never used at all, and then just in custody and placement cases, and now it's used constantly in financial cases. And many times clients are reluctant to go into it. They don't want to spend the time, they don't want to spend the money, but cases which seem that would never get settled come out of mediation with a settlement. And even if they don't walk out of the mediation session with a settlement, the mediation process tends to get them to a point where they'll settle the case later. I discussed various aspects of it in my article, but to me the most important one is the concept of choice of a mediator, because there are different mediators, obviously, there are different styles, but before you even get to it, I find there are three different classes of mediators, and the choice of a mediator by the attorneys, somewhat by the parties if they're doing it pro se as well, but they tend to be less sophisticated in terms of who they're choosing. So when the attorneys are choosing the mediator, the three classifications that I find are in existence are really critical. Before even the personality or style of the mediator. The first classification is mental health experts. And to me, if the mediation centers over child issues, particularly placement schedules, even decision-making to a certain extent, but certainly when parties get concerned about transitional issues for children, how to handle the two extremes, infants, and how to take care of infants in different theories and parenting styles, and the other extreme being teenagers and how you handle teenager placement. Those really are not legal issues. If anything, they're issues regarding child development for which lawyers have knowledge only based upon being parents themselves, which is helpful, but isn't necessarily any better knowledge than the parties themselves may have, and certainly isn't professional knowledge. In addition, a lot of times the issues presented entirely mediation, but especially when you deal with children, are more emotional than anything else. I mean, in terms of legal, where is it a legal issue if the placement schedule is 7-7, 8-4, 9-5, whatever, got the numbers wrong tonight there, 8-6, 9-5, whatever the difference is really an issue, if anything, that is emotional, that is child development centered, or deals with different parenting styles. So hiring a mental health professional, psychologist, social worker, anyone, psychotherapist, who is trained in mediation, but also has independent training and experience and professionalism in the areas of child development, in the areas of the emotional aspects of divorce. A lot of times what they're really doing is therapy as opposed to just simply doing mediation. But I find that those types of mediators are far more effective in most cases than using lawyers who, after all, are trained in more in advocacy than we are in any of the other issues that I just discussed. So my first preference when it comes to classification of mediator is if the primary or only issue is a placement schedule for children, is go to somebody who's trained in children, in how to handle children, how to understand children, how to talk to children, how to raise children in terms of maximizing the odds that they won't be harmed by the divorce process itself. If the issues are financial, then there are really, generically speaking, two different classifications of mediators. There are the retired judges and there are the older, experienced lawyers, some experience at least, that offer different benefits to the mediation process. The former judges, and Lord knows there are plenty of them that are doing mediation, it seems that whenever a judge retires, they're going into mediation, usually in one of several groups that have formed where you can hire out a judge to be your mediator. They bring one skill to the table that a lawyer mediator can't bring. And it's a very valuable skill. It's a skill to be able to say, while I'm not the judge in this case, if I was the judge in this case, this is what I would probably do. That's valuable because at the bottom line is a lot of decisions when you're mediating, especially things like child support, maintenance, and most types of property division, have a high degree of variableness, otherwise known as discretion, or room in which the judge can move. If it's outside of areas which a judge can do, that may be one of the rare cases for litigation because you can't possibly lose because the judge can't do what the other side wants anyway. But if both sides are within the wide parameters of what is known as judicial discretion, if you knew what a particular judge would do in the case, it makes a lot of sense for the parties to settle at that result. And it's just simple logic. If you knew, for example, the case is going to be tried in front of Judge B, and Judge B always orders unlimited maintenance in marriages of 20 years or more, for example, or 25 years or more, or 30 years or more, or never orders unlimited maintenance, all of which may be very well within his discretion or her discretion, it's easy to say to the client, look, you've got two choices here. You can either settle for what the judge would do, or pay to litigate the case and have the judge do it anyway. Either way, you end up with the same result. And if you know what that judge would do, then settling and saving the costs of trial is a logical thing for the client to decide on, and they're more likely to decide to do that because that's where they're going to end up anyway. There is the problem that when we say it's within the discretion of the judge, the mediator is not the judge that's going to hear the case. So the client can reason, well, that's what this one judge would do if he was the judge, but he is not the judge, and therefore I'll take my chances on the real judge who's sitting on this particular case, who may exercise his or her discretion differently than the mediator would, and that's a logical decision. But I find the course of mediation that it isn't the way most clients reason this. The way most clients think is if this is what a judge would have done, it's more likely to be what the judge in my case would do, which again is not a logical thinking. Judges, while there is a variety and there is a range of what judges do, it certainly is rational to think if one judge would do it, another judge would do the same thing. The other classification is lawyers who have practiced for any extended period of time. I've been doing mediation for quite a few years, but I never did very much, and I was never, up until a few years ago, wasn't even trained in it. I thought I was doing pretty good, and then, if you get more gray hair, take a look, right? You begin to get more calls in terms of serving as a mediator, and I thought, you know what? I'm going to take one of them training classes and see if there's something I can actually learn. I think it's pretty much self-evident how to do this. Take one side, take the other side's proposal, work back and forth, see if you get them to come to an agreement, but maybe I can learn something. And I took the UW 40-hour training course in mediation. And I was amazed at how much I learned in terms of the process of getting people to yes, which is, after all, what the goal of the mediator is eventually. So I'm going to change what I would have said 5 years ago and just find some lawyer that everybody trusts and likes and has some experience. I'm going to change that and say the lawyer should have a certain requisite amount of training in terms of being able to do this. The training really, really is helpful. And in the mediations I've done since the training, I've found that that training really comes into play and has really helped me get to a favorable resolution for the parties. The downside of the lawyer as opposed to the judge is the lawyer can't say, if I was the judge, this is what I do, because they're not the judge. I mean, you could say that, but it doesn't make any sense in the case. But the lawyer does bring other attributes to the case. For one thing, the lawyer is used to the emotional aspects. A lot of judges aren't. I mean, they may see people cry in court or act emotionally or get angry or whatever, but it's not like lawyers where we sit in our office and hear clients acting emotionally every single time. I'm going to use the gender-based examples where the guy is saying, I worked for my money. Why should I have to pay her? And the wife saying, I can't possibly work and make any money. I've been staying at home raising children all these years. Both of those have logic to it, but when they're expressed in our office by parties, they're often accompanied by a high amount of emotion. And as lawyers, we're used to that. We see that emotion all the time. We know how to deal with it in individual cases, or at least we have more experience than judges who only see a fraction of it from the bench. The other advantage of lawyers as mediators is if the case is at all complex, is dealing with unusual elements. Judges don't see that very often. I mean, most of what judges do are pretrials and defaults and maybe a few motion hearings. Don't mean to diminish the judge's role, because good judges at those pretrials are serving as mediators, and a lot of times they're doing a great job at getting people to settle the case. But the number of contested trials they hear are very small, and when they do, they tend to be two pro se's fighting over placement issues, as opposed to anything in a financial issue that's at all difficult and sophisticated. So dealing with using a lawyer as a mediator, you're more likely to have a mediator who has experience not only in the emotional aspects of the divorce, but also in the particular substantive issue which might be at play at the case. Bottom line in all of this is it's not one size fits all. I keep in my office a list of different mediators, psychologists, I think even psychotherapists, retired judges, and lawyers with a little bit of gray hair who, in a particular case, may fit the bill. So if it's, as I said, child-related, I'm going to want to use somebody in the mental health field. If it is a case which requires a heavier hand and a judge who might say, this is what I would do and you should do this, or a lawyer that may not bring that to the table, but may be more amenable to the emotional issues and more in tune with what the not only courts might do, but what some of the other options are and some of the creativity that's available in handling some of these issues. And I think it takes both lawyers to talk to each other, discuss the aspects of the particular case, and to choose a mediator that in that particular case they think best fits the bill. For more on my views as a mediator and how mediators could do it better, take a look at my article in the Wisconsin Law Journal. I go into some other areas into a family law mediation, though I expounded on this one a little bit more than in the article. And lastly, as a service and public personal service announcement, yeah, as I said, I am licensed to do mediation. I'm doing more and more of it these days. Be pleased to talk to you if you'd like to use the non-mental health professional, non-judge, but the lawyer with a little bit of gray hair. Be pleased to talk to you about doing mediation. Give me a call, send me an email. Be pleased to talk to you. Friendly reminder to subscribe to Wisconsin Family Law Case Finder. Subscription information is on screen for you. We have over 1,600 family law cases in Wisconsin, many cases from out of state, organized into 135 different family law subject areas. You can search by the word, search by the area, search by the case. It's an outstanding resource, and if you practice family law in Wisconsin, you ought to subscribe to it.